In this video, we will look at the definition and purposes of international commercial terms or Incoterms. Incoterms stands for the International Commercial Terms. Incoterms were first developed in 1936 by the International Chamber of Commerce in an attempt to simplify communication shortfalls between parties dealing in international trade. From its publication of the first ever International Rules for the Interpretation of Trade Terms, it has developed into what we now term as Incoterms. The buying and selling of goods in the international trade system can often be complicated with responsibilities, cost, and risk to all parties needing to be determined. To help traders in the import and export of trade, the International Chamber of Commerce introduced the International Commercial Terms to act as the world's essential terms of trade for the sale of goods. Since its publication, it has actually had some revisions about every 10 years or so. The Incoterms rules feature a series of three-letter trade terms in which all have very precise meanings for the sale of goods around the world. So we may define Incoterms as a series of international sales terms or rules that are widely used throughout the world. They are accepted by governments, legal authorities, and practitioners worldwide. These rules have been developed and maintained by experts and practitioners brought together by the International Chamber of Commerce, and they have become the standard in international business rule setting. So what are the purposes of having Incoterms? Incoterms provide a uniform set of rules to assist buyers and sellers in stating each other's obligations under an international contract. So Incoterms define the rights and obligations of both exporters and importers in relation to transportation of goods around the world. Incoterms provide a set of standardized and internationally recognized trade terms which mean exactly the same thing to both parties and which will be interpreted in exactly the same way by courts in every country. They help traders avoid costly misunderstandings by clarifying the tasks, raw cost, and the risk involved in the delivery of goods from sellers to buyers. They streamline and remove some of the ambiguity that can occur in a contract, especially when parties speak different languages. So they provide a basis for dispute resolutions and can be made binding on both buyer and seller, provided, of course, that the invoice specifies that a particular Incoterm will apply. Incoterms deal with the questions related to delivery of the goods from the seller to the buyer, and not the transfer of title or ownership. In global trade, delivery refers to the seller fulfilling the obligation of that applicable Incoterm, or the seller completing a contractual obligation. Delivery may take place before the goods actually reach the buyer physically. In other words, the selected Incoterms will determine where and when the risk of carriage or delivery is passed from exporter to the importer. It can be conceptually difficult to make the distinction between the transfer of title and the transfer of risk between the exporter and the buyer. Title refers to legal ownership. Incoterms does not actually specify that they go hand in hand together. Title passes usually when payment is made. Let's take an example. Scene 1. You agree to sell your friend a crystal ball and pass it to him during the tutorial. He has not paid you yet. So does the item now belong to him? Technically speaking, not yet, because he has not paid you. Now, scene 2. Your friend paid you on the spot in exchange for the item on COD or cash on delivery basis. In this case, he has taken ownership, logically speaking. But we have to take note that Incoterm is silent on when the title passes. So it is best to clarify with the buyer or seller. The transfer of title is usually based on when the importer makes payment, regardless of whether it's partial or full payment. So payment implies transfer of title or ownership from the seller to the buyer. Now, there are some traders who may claim that the title pass once the goods are loaded on the vessel, probably even for the CIF basis. Incoterm is silent on this, so it is better to clarify during your negotiation or in the contractual agreement. So take note, transfer of risk is independent of whether the payment has been made or not. Now, if you are the seller and payment has not been made, you may want to protect yourself by having what is called retention of title clause in your contract. Incoterms do not constitute a complete contract of sale, but rather become a part of it. So you should incorporate the Incoterms into your contractual agreement. How do you incorporate this term into your contract or invoice? Well, you have to state clearly in the documents or the contract the chosen Incoterms rule, the name port or the name place or point, followed by Incoterms 2020. So for example, in this case, CIF Sydney, New South Wales, Australia, Incoterms 2020, or DDP 500 Dover Road, Singapore 139651, Republic of Singapore, Incoterms 2020. Now, so it is crystal clear that in this case, the place of delivery is right at the door of Singapore Poly, at Dover Road itself. So are you ready for the lineup of the 11 Incoterms rules? This visual chart may be easier for many of you to remember the Incoterms. Let us get to know them in the next video. We have come to the end of this video. The next video will introduce you to the 11 Incoterms based on the 2020 version. Stay tuned.